Hi there. Today we are going to look at elements of a valid contract, basically what it means by formation of a contract. I want to first interest you in the definition of a contract as provided for under Section 9 of Contracts Act, which basically defines a contract as an agreement made with free consent of the parties uh, for a lawful consideration with a lawful object and with an intention to be legally binding. That is basically the definition of a contract. The definition covers a number of aspects. For you to say that you are making a valid contract, you are basically you need to understand that it covers a lot of things, which include acceptance, which include capacity to contract, which also include consensus and idiom, meeting of minds, to include, you must be capacity, as I have said. There is also an intention to be legally binding, and there is offer and acceptance. Also, you cannot forget that there is also consideration. Those things make up a valid contract, and whenever you have a contract or you have an arrangement that covers all those aspects, then you have a valid contract. I will break it down by discussing each aspect. I will begin with an offer. I break it down. I let you understand what amounts to an offer. An offer is defined under Section 1 of the Contracts Act as the willingness to do something or abstaining from doing something signified by another person to another with the view of obtaining assent of that other person. Basically, here, under an offer, you are offering. Someone is saying, I'm doing this, or I'm giving you this, and he has that feeling that you will either accept by doing or by not doing. That is what it means by an offer. What you need to know is that an offer can, that there can be no contract. There can be no contract, or there can be no valid contract concluded unless an offer has been made by one party to another person. And that the mere making of an offer does not necessarily make a contract. All other elements must be included. That offer must be accepted. That offer must be communicated. The person must accept the offer, and that contract, that offer should not be illegal. That is very, very important. You cannot offer to sell something illegal and you expect someone to accept it. Yes, they may accept, but that arrangement will be against the law. Where I wish to interest you in the case of Career versus Kaborik Smokeball Company, and that case will really guide you on what it means by an offer, by acceptance, by being legally binding, by communication of the offer, by communication of acceptance. It is a very, very important case that covers all the elements of a valid contract. It's a case of 1893, volume 1, Queen's Bench at page 256. In that case, the facts of that case, the defendant issued a newspaper advert to the effect that they had manufactured a product known as smoke ball, and anyone who used it and caught influenza. At that time, there had been outbreak of influenza. I hope most of young people do not know about that, but it was an outbreak in some years ago. So the company is saying that whoever uses their medicine and catches influenza will be paid £100. Of course, as an assurance, the company went on and deposited £1,000 with the bank to make it so that people should be sure that in case of anything, they are ready to pay. Of course, having had already the announcement, the newspaper advert, Career had caught influenza, she purchased that wonder drug, used it as prescribed, and caught flu. Of course, she sued for recovery of that of the money, and the company argued that in their defense that it was a mere puff. Of course, that was the defense, and of course, in the court held that they had intended to contract, therefore they should pay. I will interest you in the decision of the justice in that case, where Lord Landley heard that there was a general offer that had been made to the whole world that anyone like Career who comes up and performs on the strengths of the advert will have accepted their contract, or will have accepted in the offer in the legal sense. It, however, seemed that the court has to consider each case on its own facts, e.g. by analyzing, that is the analysis. We are trying to say the court has now to analyze facts of each case. Court went on and said that by assuring, that in the process of assuring the public that they are ready to pay, they decided to deposit £1,000, where they would apportion the £100 to pay in case any person uses their medicine and fails to heal. Very, very important. I will interest you in the type of contract made in that. In the case of Career versus Kabori Smokeball, is basically known as a unilateral contract. These are contracts made to the general public, because actually in that case, the question before court was whether a contract can actually be made to the whole world, to a very, very big number of people. Such contracts exist, and the type, they are basically known as unilateral contracts. Those contracts are subject to performance of a certain act. If you perform a certain act in respect of the offer, then you have accepted the offer. Very, very important. You need to appreciate that. Contracts can be made to the whole world. However, you need to analyze very, very critically, because we have been seeing adverts in the newspapers. Coca-Cola is advertising, MTN is advertising. You need to read the facts of that advert. You appreciate it. Some of these are just mere arrangements, mere puff, as the respondent in that case argued. They are mere puff. But in this case, it was really, really a contract. We need also be guided. At what point is a contract made? At what point is an offer takes effect? At what point is an offer takes effect? Actually, before we go to when a contract takes effect, I wish to interest you in what is known as an invitation to treat. Invitation to treat is an aspect different from an offer. Invitation to treat is an aspect different from offer. You need to appreciate it. Here, the good example we have is how goods are arranged in the supermarket. Goods are there as buyers, as consumers. You come and treat them with your eyes. Pick goods you want. Then offer. Then it is you now offering to buy those goods. There is no any contract concluded when you are picking goods. A contract will be concluded when you stand to the cash desk and pay. So when you're picking goods, we can't say that those goods were offered for you to buy. You're just treating them with your eyes. You're just treating them with your eyes. So when you like the goods, that's when you offer to buy them. Very, very, very important. I will interest you in the case of Fisher versus Bell. In the case of Fisher versus Bell, this person was selling knives in the windows. The knives were arranged in the windows. So, of course, it was illegal at that time. The law said that you cannot sell these knives. Actually, allow me interest you in the facts of this case, the Fisher versus Bell. It's a case of 1960. A shopkeeper displayed a freaky knife with a price tag in the window. The restriction of the Offensive Weapons Act of 1959 made it an offense to offer for sale a freaky knife. The shopkeeper was prosecuted in a magistrate's court, but the justices declined to convict on the basis that the knife had not in law been offered for sale. Very, very, very important. This decision was upheld by the Queen's Bench Division Court, where Lord Parker CJ stated that it is perfectly clear that according to the ordinary law of contract, the display of an article with price on it in a shop window is merely an invitation to treat. I want you to note this, that displaying a knife or any object or any item in the shop window is not an offer for sale, but an invitation to treat. It is in no sense an offer for sale, the acceptance of which constitutes a contract. I hope you note that it is not an offer for sale, it is an invitation to treat. Therefore, if you offer to buy, then you are making a contract. It is now upon the shopkeeper to accept your offer. That is very, very important. You need to appreciate that. I repeat the words of Lord Justice Parker. He says, it is clear that according to the ordinary law of contract, the display of an article with the price tag on it in a shop window is merely an invitation to treat. It is in no sense an offer for sale, the acceptance of which constitutes a contract. Therefore, if it's not an offer that if you accept, then you are making a contract. It is you now who should offer. I hope you appreciate that. On the same aspect, I will interest you in the case of Great Britain, Pharmaceutical Society of Great Britain. It is also a nice case versus Boots. It's a case of 1953. It's a very nice case on invitation to treat. It will also shed light on that. You will allow me proceed. We look at acceptance of the offer. How can no, actually, before we go to acceptance of the offer, let us first tackle communication of the offer. At what point is it important to communicate the offer? That's a question. Is it so important that an offer must be communicated? Yes, under the law, it is important to communicate the offer. I will interest you in Section 2 of Contracts Act, which basically talks about communication of an offer. That communication of an offer takes effect when it comes to the knowledge of the person to whom it is communicated or to whom it is made. If I made an offer and it comes to the knowledge of the person that I'm intending to offer to, who is known as the offeree, then the communication has taken effect. It means now I'm waiting for him or her to respond to my offer. Very, very important. If he does not receive the information regarding my communication, then we cannot say that he has that he has received the offer. You need to note that. We cannot say that someone has received my offer if it has not come to his knowledge. I keep emphasizing that so that you don't fall victims of such circumstances. I will interest you in the case of Ara versus Kelak, and this case is a case of 1927. It's an Australian case. In this case, the government offered a reward for the information leading to the arrest of certain murderers and a pardon to any accomplice who gives the information. Kirak saw the proclamation. He gave the information which led to the conviction of all of the murderers. He admitted that his only object in doing so was to clear himself of the charge of murder, and that he had no intention of claiming the reward at the time. He sued the Crown for the reward. The High Court of Australia dismissed the claim. Justice Higgins stated that Kirak had seen the offer indeed, but it was not present to his mind. He had forgotten it and gave no consideration to it. In his intense excitement as to his own danger, there cannot be an assent without knowledge. Very, very important. You need to note the words of this justice, that there cannot be assent without knowledge of the offer. You can't say that I have accepted the offer when you personally don't know about the offer. When you appreciate this case, this one, they said if you bring this person, we shall pay you this money, or we shall acquit you. But for him, because he wanted acquittal, he had no intention of saying, of getting the reward. His main intention was to be acquitted. So when he sued for reward, even after the acquittal, the Crown Court said, no, you had no intention of taking the reward. You actually had no knowledge about whether we are giving the reward or not. So at the end of that day, they denied him that reward. The main important point here is that you have to note is that there cannot be assent without knowledge of the offer. And the ignorance of the offer is the same thing whether it is due to never hearing of it or forgetting about it. If you forget about the offer, for you are sent on some other thing, though it may be collateral, but you can't then again later claim the reward because you forgot about it, you had no knowledge about it, or you were not interested. That is very, very important that you need to. So basically for communication of the offer, you will need to appreciate Section 2 and Section 3 of the Contracts Act. In Contracts Act, it is very important to appreciate these provisions. And again, you also have to appreciate facts of each case, because cases are different. Every day you meet a new case, maybe having almost similar facts, but something very small will make it different. So you need to appreciate the law, appreciate the contents of the act, appreciate the contents of the facts. Because once you misinterpret the facts, then you finished. Once you misquote the law, then you finished. This applies, I believe this applies to every law, every course unit, whether you're in year 2, whether you're in year 3, whether you're in year 4, whether you're at LDC. This applies to every law. You must appreciate every law. Appreciate what the law says, apply it to the facts. Even sometimes you find that the facts don't need your law. You look at the facts and appreciate them the way they are. That is very, very important that I felt I should clarify. Let us proceed and appreciate the termination of an offer. How can an offer be terminated? How can an offer be revoked? Like, can an offer be terminated? Can an offer be revoked? Can someone reject the offer? Yes, it is possible under several circumstances, as we are going to discuss them here. One of the ways we can, before we go to these ways, allow me interest you in Section 2 of Contracts Act. It basically provides it provides for communication of revocation. That communication of revocation takes effect. You must communicate that you have revoked the offer. You must communicate that you have revoked the offer. It will interest you in Section 2, subsection 3, that the communication of revocation of an offer or acceptance is made by an act or omission of the party who revokes the offer or acceptance respectively, which that party intends to communicate the revocation or which has the effect of communicating the revocation. You must communicate that you have revoked the contract or the offer. That's what I'm trying to emphasize. Let us, you also have to appreciate Section 4 of Contracts Act. You also have to appreciate Section 5, which provides for modes of revocation, basically, like we are going to discuss here. Under what mode? Which modes? What do you think? What do you believe can revoke the contract, the offer? The offer. I will first interest you in the case of Karid versus Atehans Brothers, Eden Limited. Is a case of 1968, East Africa, at page 31. The facts of that case are that the majority stakeholder in the company offered to buy a minority stakeholders holding. A formal document was made for his signature, but he objected to the payment provisions until alterations were made. Then he signed. The majority stakeholder then purported to revoke his offer. The issue before court was whether the offer could be revoked. The issue before court was whether the offer could be revoked, and the court held that the majority stakeholders' demands amounted to counter offer, and the majority stakeholder court held that the minority stakeholders' demands amounted to counter offer, and the majority stakeholders purported revocation was invalid since the other party had already accepted and signed the agreement, forming a contract, and the violation of which would amount to breach of a contract. This case concerns itself with counter offer as one of the ways of terminating an offer, of revoking the offer. So let us basically talk about counter offer as one of ways of revoking the offer, even a contract, and just basically an offer. Basically, what you need to know about counter offer is that it invalidates the original offer. That's the effect of counter offer. You need to note this, that counter offer invalidates the original offer. Let's give an example of what amounts to counter offer. Let's say Alex offers to sell Maurice a house at 20 million on 10th December, let's say, of 2009. On 12th December, the same year, Maurice tells Alex that he is ready and willing to pay 10 million. Alex then sells the house to Yaronda, let's say, the day later. Then Maurice now calls Alex that he is now prepared to pay 20 million. The question here will be, has Alex breached a contract? Then another question will be, is there still any contract between Alex and Maurice? If you have heard that scenario very well, Alex offered to sell the house at 20 million, but for Catherine said, no, I pay you 10, I give you 10 million. It means now Catherine is giving herself a new offer, is bringing in a new offer to pay 10 million and not 20 million. It means basically that one counter offers the first offer, invalidates the first offer. In this regard, the offer, Maurice's offer amounts to a counter offer and is a rejection of the original offer by Alex. That is very, very, very important. I will also interest you in the case of Hyde versus Range. It also concerns counter offer. It's a case of 1840. It's basically a case of 1840. The facts are that the defendant on 6th June offered to sell an estate to the plaintiff at £100, at £1,000. Then on 8th June, in reply, the plaintiff made an offer to pay £950, which was refused. by the defendant on 27th June. Finally, on 29th June, the plaintiff wrote to that he was now prepared to pay £1,000. Of course, by the virtue of now the defendant saying at first he said no, I'm giving you 950. That means it is a counter offer. He is invalidating the offer that the defendant was giving at first. Then again later he accepts to pay. There is no contract that this person was accepting, because there is no actually the offer that this person is accepting, because he had counter offered it at first. I hope we are moving well together. In this case, court held that no contract existed, that by his letter of 8th June, the plaintiff had rejected the original offer, that he was no longer able to revive it by changing his mind and tendering in subsequent acceptance. That is very, very, very important. As I earlier noted, you will also be required to appreciate the principle of counter offer by reading a case of Karid versus Atehans Brothers Limited. It's a case of 1968, East Africa, at page 31. You can also read a case of Dixon versus Dodds, a case of 1876 at volume 2. At page, it's basically a case of 1876. That is very, very, very important. Another mode of revocation of the offer is basically death of the offerer, even death of the offeree. But in most cases, it can be by death of the offerer. Here, I offered, God forbid, but I offered to sell you something. Then later, I die. It means the offer is automatically terminated, because the person who had offered is no more. We cannot now, or you cannot now, accept the offer. Now to who? Because you are not accepting to anyone. Generally, you need to be guided that death terminates the offer. However, it depends on whether the transaction is personal or impersonal. For example, does the offer or acceptance require personal performance of the prospective offering? In the case of, you need to be guided that in the case of personal transaction, the offer is automatically terminated when either of the parties dies. That is really, really very, very important. It is very important. I will give you, like, here is an example. In an impersonal transaction, you however need to know that the offer may not be affected by the death of a person. For example, if Anita offers to sell land to Bosco at 10 million, if Bosco pays a deposit of 2 million and dies the next day, Bosco's legal representatives can take up the matter in the names of the deceased. That is the law. Bosco's legal representatives can take up the matter in his names, and the contract continues. That is one of the things that you need to appreciate. Then another mode of revocation or termination of an offer can be by lapse of time. Most of these contracts are time-bound. Not time-bound, but they are time-bound. Like, you say before June or before September, before October, you should have done this. I have let me give you an example. I may say that I'm selling this land. Whoever is willing to pay 50 million for this land should confirm with me before 2025 or before December 2024. I want you to take these words clear. Whoever, I'm selling my land, whoever is willing to pay for this land should confirm with me before December 2024. A contract, this offer will be open for anyone interested to accept it for the period before December. It means past December, the offer will be automatically terminated because time has elapsed. That is what I am trying to emphasize on lapse of time. You need to appreciate that. I can give you another good example or scenario. Like, let's say Diana offers to sell Alex 10 sacks of tomatoes. The offer was made on 6th August, let's say 2015. Diana informs Alex that they are already ripe in the garden. Now Alex takes 2 weeks before he responds to Diana. 5 days later, Diana decides to sell tomatoes to another person. After 2 weeks, Diana receives Alex's acceptance. Diana informs him that tomatoes were already sold, and Alex threatens to sue Diana. What's the legal position? Can Alex sue Diana for breach of a contract? That's a question. There is, I wish to interest you in something like reasonable time. When I'm selling land, the reasonable time of responding to that offer is different from when someone is selling tomatoes. You need to take this very clear. Therefore, you need to appreciate facts of each case. You look at the nature of goods being sold. You look at the purpose, the need for which someone is selling these goods. Are these goods perishable? If they are perishable, then what could be the reasonable time? That is, if time is not defined within your contract. Therefore, depending on the scenario we have at hand, it will not be possible for Alex to sue Diana because the reasonable time for responding to this is over. Because you can't keep tomatoes for 2 weeks. Yet at the time of making an offer, Alex is already informed that these tomatoes are already ripe in the garden. You have to mitigate. You have to mitigate and see what works best. You can't keep them for how long? And are you very sure that he is willing to buy them? Because you may find that he is no longer willing. So the offer automatically is terminated when time lapses. The offer is gone. That is very, very important. That one of the things that you need to appreciate on termination of a contract by lapse of time. Reasonable time is also important, and when you are lucky that time was defined in your contract, if you go beyond that time in the offer, I mean not in the contract, if the offerer had specified time for which the offeree should respond. If you go beyond that time, then you are out of time. Time has elapsed. I now have the liberty to offer to another person or to say I'm no longer willing to sell. If you have failed to respond within the time specified, then we are out of time. That is very, very important. Allow me proceed to another aspect where a contract is deemed to have, where an offer is deemed to have been terminated and you can no longer accept it. We have what we call conditional offers. When an offer is conditional, I will first give you an example. Let's say I say I'm selling my laptop, and whoever is willing to buy it should, let's say, pay 2 million, and also like, if you're willing to buy it at that specified money, you are the one to pick it at my office. It's conditional that whereas you buy it, you will have now to drive to my office and pick it. It's not subject to delivery. I'm not delivering it. If you're willing to buy it, you buy it. So it means if you fail to do that condition of coming to pick it, then the offer is automatically terminated. Because you are not willing to be subject to these other conditions. Let me give you some other example of, let's say, the US government offers to provide ARVs for Uganda for the next 10 years. And again, the US government says, for us to provide ARVs, you must legalize homosexuality. This is a very nice example that will shed light on what we are talking about. The government of US is saying we shall supply you with ARVs for the next 10 years, the next 15 years, the next 30 years, but you must legalize homosexuality. Now it's up to Uganda to sit and decide, are we becoming homosexuals just because we need ARVs? Are we not taking ARVs just because we don't want to be homosexuals? If Uganda says we are not becoming homosexuals, we are not regularizing homosexuality, then the offer is automatically terminated. That is one of the ways an offer can be terminated. You need to appreciate it. I may not proceed to give you more other examples on termination by when an offer is conditional, but you just have to appreciate a few examples I've provided with you. Let me proceed and look at another example of how an offer can be terminated. As I earlier discussed, you need to appreciate the doctrine of revocation. Someone can write to you after you have offered. Someone can write to you and say, I'm not interested in your offer. I don't want to buy. That is by he has automatically rejected the offer. You go, let's say, you call him and say, my friend, I'm selling my car. and he will be like, no, I'm not buying. That's automatic revocation, automatic rejection. You appreciate the section 2, section 3, section 4, section 4 and 5 and 6. It provides for all these things about termination, revocation, communication of the offer, communication of revocation. Basically, that's what I had to share with you today. Thank you so much. Keep sharing, keep following, share with your friends. Let them benefit like you have benefited. Otherwise, I wish you well. I wish you the best in law school. Law school is the best place where you can learn and unlearn. Appreciate every principle. Appreciate anything that your lecturers teach you. Always consult your colleagues for more enlightenment about these principles.